gentlemen, welcome back to the Founder Memo podcast. In fact, we are changing the way we are doing this podcast here at Corpora. The Founder Memo, because Corpora is all about helping founders through bringing insights from world-class members of the startup ecosystem, other founders, exceptional lawyers, investors, and others who make this ecosystem tick. My name is Stepan Khazaretsyan. I'm the co-founder and CEO of Corpora. Corpora helps startups close their rounds faster while automating the admin work and bringing on top-tier startup lawyers to lead the strategic work. My guest today is a good friend of mine, an exceptional startup lawyer as well. This has been a long time coming. I've known Tamir for over a year now, and I'm super hyped to have Tamir on the show. He's zooming in from the Bay Area.
That's right. Yep.
Tamir, great to have you. I'm going to read out your super impressive bio. Tamir comes from a BigLaw background at WSGR, then worked in a strategy and operations role at Atrium. Professional career is mostly dedicated to trying to hack startup law, refactoring law firm incentives, and thinking about how to achieve cognitive resonance of being a human while being a professional. Tamir, so great to have you on the show.
Yeah, likewise, man. Thank you so much for having me.
Absolutely. And let's get right into it. I want to start from today, and then we'll sort of work our way back to the early days. Legal and Ops. You've been running this boutique practice for a few years now. Beautiful boutique practice, tech enabled. You have this thing called the Lean Legal Startup Minifesto, fractional GC services. You got a lot of good stuff going on, man. Could you unpack it for us, for our audience today? Like, why do you do what you do? Why you do it the way you do it? And why do you think this is the future of how startups should access legal services?
Right. Thank you for the bio. Thank you for the setup. I think what motivates me might be at least in part a sense of spite. If I'm being totally critical with myself, I think being in BigLaw at times, just like in probably any job today, you're like, why do we do it this way? And kind of being stubborn in that direction can, I think, sometimes result in people wanting to try things out a different way. And at Legal and Ops, we are fundamentally built on the idea that specialization leads to more value. Same way assembly lines create more efficient processes. You have different components doing specific things better than any person or other tool could. So just like Corpora is optimizing the financing process, or like Clerky might optimize formation, or Pulley does equity grants, each of those tools plays a role, sometimes several, in the legal jobs to be done framework. And meanwhile, lawyer specialists, privacy attorneys, tax attorneys do their own thing. So the thesis for us is if you have a part-time fractional general counsel, especially one that's more technology or operations forward, they're the person that can build or manage that assembly line of these specialized tools and then triage the day-to-day tasks that those tools aren't built for and source the right specialist for everything else. So does that all make sense?
It does make sense. And the metaphor that comes to mind just now, and correct me if this is not on point, the fractional GC acts like a conductor. So you have a whole orchestra of tools, a whole suite of tools, and then you have your bespoke, your acumen as well, and then you weave these in and out based on the client's needs.
Yeah, I think it's right on point. Yeah.
Awesome. And why did you decide to focus on startups specifically? Legal and Ops website bills you as the go-to law firm from incorporation to Series A. What makes you tick about this lifespan?
Yeah, I think it's where I feel the problem maybe exists most acutely because founders are tempted to use self-service tools, rightly so, because they're budget sensitive or they feel this is commodity work because their company is still brand new and they don't have a lot of unique kind of circumstances that require deep legal work. So that's where so much legal work can or should be viewed as rather commodity-like. It's not reinventing the wheel. And at the same time, totally self-service is sometimes scary or results in more work than founders might like or feel comfortable doing. So that's why fractional general counsel to me really makes sense that segment.
Yeah, I'm with you in terms of that fully self-service tools can be scary. And sometimes it's not just a matter of the self-service tools being bad, but the user not knowing how to use it or not having the time or will to learn how to use it. And
Right.
that can be a very scary way of using self-service tools.
Yeah.
And so I
Yeah.
wonder, and this is something that we try out at Corpora, if we can program the guardrails so that the user truly cannot mess up the process unless they
Right.
really, really wanted to. And I think
Right.
all self-service tools should be like that, although we don't sell ourselves as a self-service tool.
So how do you think about the end user for you guys and who you put in front of the driving wheel for all of it or parts of it in light of that?
Yeah, so the way we're building it is we do have the self-service tools for founders, for just like you said, the commoditized stuff, the standardized stuff, for them to take care of that component. But in the meantime, we're building Corpora as a platform where they can collaborate with their lawyer, or if they don't have a
Right.
lawyer, we introduce them to the
Right.
lawyer. And the lawyer
Right.
has context at any given point they can take over or jump in as needed, as much as needed. So in a sense, Corpora's role here is very much like a conductor as well, in fact, although we see ourselves as a dispatch. So when the founder comes, depending on the type of legal need that they have, we either point them to the self-service tools and help them figure that out,
Mm.
or we point them
Hmm.
to the attorney for the high stakes strategic work that really
Right.
needs the acumen of the lawyer.
Makes a lot of sense. Interesting. Yeah.
And speaking of technology, you're one of the rare lawyers that is building tech. You're both running a full-time practice and you're building product. You're building technology that I've been fortunate enough to have a look at. Um, what led you to this, and how is this going? How does it feel being a lawyer slash developer?
Oh man, I have definitely learned I am not a naturally talented product guy, and that has been a painful and expensive lesson. So there have been deep learnings there. I'm curious to hear your experience as well, but I know you're supported by very talented Suro. But uh, for us, I think there's like three levers that I see in value: good, fast, and cheap. Um, and uh, fast and cheap kind of go together for that like specific segment I think I described. Once you have like a clear scope of jobs to be done, and especially when they're pretty rote or commodity like repeatable, then it's like the perfect use case for some combination of technology and operations practices to uh, bang those things out consistently. So I think fast and cheap like go together quite smoothly. Um, and then it just leaves good. And because of the reality of liability as practicing as a lawyer, um, as well as anyone's expectations of the kind of work they want to associate themselves with, good is kind of non-negotiable. You might change the scope of what you're doing. That's good to be more narrow, like more specific
Mhm.
use case. So yeah, I think the short answer is I see those three levers as things to play with. Technology and operations facilitates faster and cheaper, I think, production of commodity work. And so, therefore, like a lot of great firms, I know you had Nareg on to talk about this from Decrypted as well. Fixed pricing, it makes a lot of sense for these kinds of repeatable tasks. So, yeah, I think our goal was to facilitate fast and cheap uh, by leveraging technology. So, more of a means to that end than just for the sake of having technology.
Yeah, and it also allows you to, just like you mentioned, play around with the prices, right? If you have technology that automates that grunt work, you'll be more comfortable quoting flat fees to the end user, and flat fees
Right.
usually means certainty and transparency to the end user.
Totally. Yeah.
Mhm.
And in that effect, that's what you guys are doing as well, right? Series like early stage price to equity rounds. Would you characterize them as kind of like commodity like or fitting a pretty standard playbook in terms of how they're executed?
I think it depends. There's this fundament, the foundation of work that is pretty standard. Term sheets are
Yeah.
pretty standard. MVC adjuster
Right.
standard. That being said, it does differ case to case depending on pro rata rights and how many convertible rounds have been done before these are converting to this round. Um, every startup is different in terms of co-founder relationships, vesting schedule amendments, board expansions. So a bit of both. Based on my experience, it's been about 2/3 to 3/4 of that work is largely similar. But oh, that
Right.
1/4, oh, that quarter, it's
Yeah.
where
Right.
yeah, you have to have the expert lawyer involved to really drive the process forward.
Totally.
And from that perspective, Tamara, it's a matter of marrying technology and legal acumen, building this hybrid model, and
Right.
combining the best of both worlds. Because one comment I make often throughout the time span of my experience as a lawyer, I've noticed founders doing one of two things. They either try to do it themselves, they rely on dubious sources, and they end up screwing up big time, just like you mentioned, right? Self-service tools can really come back and bite you. The opposite has been founders relying on lawyers for everything, including the not so legal tasks, the tasks that can be automated,
Right.
that you're automating through technology as well. And then the bill racks up very quickly. So if we
Right.
can marry the best of both worlds, having technology, primarily AI, automate the admin work, but also bringing on the top tier attorney to take care of the strategic work, the acumen work. That's a win-win-win. That's a win for the customer, win for technology, win for the lawyer.
I totally agree with that. The piece I'm particularly interested in, and would be curious to hear your take on, is like where you're seeing AI plugged in specifically to Corpora's work streams in running financings, or like early stage startup work. So I don't know. I'm curious if you have any perspective on that.
I'm I'm a sucker for organization. I love keeping things organized, documents
Yep.
organized, and man, that was my
Yep.
main pet peeve.
Yeah.
Clients would share a Google Drive folder titled "legal," and they would say, "Yeah, this is my data room. This is my data room. This is all I have for legal." And then you would go in there, you would find Word documents, signature pages without the actual document attached to it, and that was essentially the seed concept behind Corpora,
Right.
automating document management. And to your point, that's how we started with using AI. So that one folder, drag and drop, and have AI build an actual data room.
It makes a lot of sense. Workflow management. I think an easy thing to go to is like generating contracts, or using AI. And frankly, I'm less long on that for this super early stage segment, because it's often there's a premium in being just like everyone else, having a standard form. But workflows makes a ton of sense. Yeah, I'm really looking forward to trying it.
Hmm. Speaking of technology and legal tech particularly, after working at WSGR for a couple of years, you went to the business side of law at Atrium, and you were leading business operations. I remember the day I found out about Atrium. It was a beautiful day, being passionate about legal tech, and Atrium was truly the poster child of legal tech for several years, and you were in the heart of it all. Seeing what you saw, knowing what you know, what learnings would you share with our audience? Because we have both founders listening in, legal tech professionals listening in, lawyers listening in, that they can take
Yep.
from you and apply it to their practices, regardless of where they are in this field.
Right. I think I would caveat that I was there towards the last roughly year of Atrium, and missed a lot of the journey that got us to where we were. But speaking from what I saw towards the end, I think kind of two key takeaways or experiences I felt that resonated or were powerful. The first was around getting people bought in, or getting people's expectations set correctly, especially lawyers. Um, and in building a technology-enabled law firm, it's not super clear who that technology is for. Is it for the lawyer that maybe wants their job to be a bit easier, that feels that practicing law shouldn't be so difficult? Or is it for the consumer that expects delivery of work product in a consistent way, or to be able to see how the sausage is being made or where it is in the process? And I think that expectation setting around who is the like fundamental user of this technology and who does it benefit, uh, was something that uh, maybe Atrium equivocated on or tried different things around. And as a result, um, if nothing else, I think one of the key stakeholders, the legal department, probably didn't quite have expectations set in the right way, um, and resulted in a lot of friction. So that's one takeaway for me around expectation setting or stakeholder buy-in, is having a clear sense of who you're building for. The other one I'd name is around incentives. I think two ways it manifested in a traditional law firm. You have often partners who are rainmakers. They bring in business. Those relationships are closely held. Attorneys help service it. Um, at Atrium, we had venture money and we had marketing. We had a lot of resources dedicated towards bringing in clients that were not traditional lawyer client relationships. And so attorneys ended up owning those relationships, which is great. They had very personal relationships with their clients, but the firm didn't necessarily own relationships in the same way that a traditional law firm would. So if a law firm decided to leave, which I think happened very little until the end of Atrium's time, then they would take their clients with them, and that was quite, I think, disruptive to the business. So that element of incentives, as well as the fact that lawyers were evaluated on largely net promoter score, which I think is a very interesting metric in good ways and bad ways, but weren't as motivated to capture revenue. And I think that resulted in some dissonance between what the firm needed and what the lawyers needed. So I think the second key experience for me or takeaway was around incentives.
Mm-hmm. I want to double click on that. If I heard you correctly, lawyers were the ones who were building and catering to the relationship with the client. And when that lawyer left, they took the clients with them. So the tech company wasn't able to position itself between the client and the lawyer. And did they want to do that? Or was this sort of an afterthought?
Yeah, I think it interestingly kind of relates to the first piece where we invested a certain amount in technology that was meant to, at one point, improve lawyers' experience of doing work, at another point, improve the consumer's experience of consuming legal.
Mm-hmm.
The tech was kind of dispersed in that way, I guess you could say, among these stakeholders. And as a result, I think didn't have the same kind of anchoring effect to preserve client relationships that otherwise would have.
Mm-hmm, mm-hmm. And the first point you made was about defining the stakeholder. And I recall our initial conversations when we were thinking
Yeah.
about the attorney ambassador program. You made the same
Yep.
comment of
Right.
being very clear of who your stakeholder is. Now, in a law firm setting, this is a given, right? You're providing your services for the client. But when you build legal
Right.
tech or any kind of tech for that matter, it's not only a matter
Yeah.
of defining the stakeholder, but being very meticulous, very detailed about what that stakeholder looks like.
And it's so hard to do. I think it's something that even with my like lessons from Atrium, I find myself like equivocating on or not being sure about. That's why I was curious about your perspective, and it's feels slippery or feels tricky to navigate correctly and to commit to, and to know when maybe you need to change how you've committed to it.
Yeah, it's a function of having limited resources. Resources being time, cash, people. You
Hmm.
definitely cannot go after everyone. And if you do, you're just going to make a product that a lot of
Right.
people might like, very lukewarm,
Right.
as opposed to a
Totally.
small group of people will absolutely love and be passionate about. Um, which we've been testing out at Corpora as well. And our ideal customer right now is the Delaware Corporation that has been around for less than 2 years. They're thinking about raising their first funding round, whether safe or price round or convertible note for that matter, in the coming 6 months. And they are not regularly working with outside counsel. And so when they come to
Mm.
us, we give them the self-service tools and we connect them with one of our attorney ambassadors to handle the
Right.
bespoke legal work. So that's what we're really honing in
Right.
right now and trying to figure out if our product can best serve these people or not. And based on those learnings, we might change it again. It's a very iterative process, and I kind of liken it to the startup being a detective or those who are building the tech being a detective and trying to solve a crime that you're not sure actually occurred in the first place. And they're
Yeah,
talking with people, they're observing behavior,
right.
and trying to figure it out. And the crime here that may or may not be committed is whether you have product market fit or not, like the holy grail of building a startup.
I think one thing that you've been very good about, and that Corpora has been, I think, successful in, which is so important to what you're describing, is having short loops. Like, I feel like you guys do tend to launch very quickly, and in my experience, have been very close to asking us about feedback. And um, I think that's just like a necessary condition of what you're describing. So, good on you guys for doing that, and I draw some inspiration from it. So,
Thank you.
yeah,
Thank you. Goes both ways, and thank you for all your help, man.
yeah, of course.
Speaking of building, building isn't just product, building is also content. And you do an amazing job on LinkedIn putting out thought leadership in the true sense of the word. You write a lot about the strategic matters, primarily MSAs, SaaS agreements, sales agreements, contracts, playbooks. And it's not simply a matter of do this, do that, but it's getting very strategic about it. You strike a strategic chord. What are some best practice tips that you'd like to share with our audience today in terms of, they're getting an MSA, say they're enterprise, they sell to enterprise, or they regularly handle MSAs, maybe with their own vendors. What should they keep an eye out for?
Um, I put it in two buckets. The first is structurally. I think online terms, self-service where possible, I believe reduces friction. Granted, less so with enterprise customers, but I still believe that you will probably get fewer red lines if you start from a place of an online terms. The second is where possible, kind of appealing to authority in the starting point by using a market standard paper for whatever the case is, common paper, bond terms, standard draft, great places to look, YC sales order form. It does create some narrative that you can commit to, that we're sticking to what we perceive as a standard in the industry. Can we roll with this? And the third kind of structural uh, hack, I guess, would be around business incentives to close quickly, whether that's adding features or hopefully not, but maybe discounting the price to reflect the sales cycle, to reflect your transaction costs with your lawyers. Um, I think those three structural elements, online terms, appeal to authority, business incentives, are the most powerful for facilitating that process. And then in terms of the substance of the agreement, just knowing like what your hills to die on are. So obviously, like business terms around termination, pricing are key, and then the typical like legal dances you do around limitation of liability, indemnification, and IP would probably be the tier one like bucket substance. So
Hmm.
yeah, that's kind of how I think about it.
And so when you say online terms, you mean the online terms of service or terms of use that the user just checks off and moves forward?
That's right, click wrap. It does have
Click wrap.
some enforceability issues, as you're probably aware, but I tend to think the trade off makes sense, especially with
Yeah.
sophisticated customers.
Sounds like a contract of adhesion, the ones that you get when you get to AT&T or Bank of America. It's like it's
Yeah,
this. It's like we can't edit a web page. Like it's there. Like we can't change
right.
anything in there. Just like you get a contract
So
with AT&T.
that's right. Do you first of all, do you have a view that those kinds of self service or click wrap agreements are problematic in that way for that reason? The contract of adhesion kind of element.
I don't think so. I think I mean there are different layers of this, right? There's browser wrap, there's click wrap, and then there are levels of
Mm-hmm.
click wrap. Like, do you accept the terms when you sign up, and if you do, and if it's hyperlinked, and if it's the default is the checkbox is unchecked and you have to actively check it, then
Yep.
I think
Yep.
that's as much an expression of consent as it is when
That's my view too.
Sue buys a cow from Jacob from the market in our
Right.
black law
Right.
contract law examples. So to my ears, it's legit. I would be wary of browser wrap, and that's when you get the terms
Right.
of service at the bottom, and somewhere there it
Totally.
says, oh, hey, if you typed in our web page address and you clicked enter, or you hit enter and you ended up here, you by default agree to the terms. And I think that just doesn't fly.
I'm totally with you on that position, and it's a bit of a shame. I think like the AT&T contract example. Obviously, no consumer is reading that or able to negotiate it. Yet they don't really have a choice. I have less sympathy for big enterprises that are opposite this because they're well equipped to negotiate it. So yeah, I think in that circumstance it feels quite comfortable and
Mhm.
reasonable to me.
I also think it's a function of the price of the services, right? If you're selling to SMB, if you're selling to consumers primarily, right? You're not going to go and negotiate the terms of service of Instagram or the next up and coming
Right.
consumer product. However,
Right.
if as high up you go into the food chain, so mid market enterprise, terms of service become less of a thing, and then you enter into MSA land or SaaS agreement land. In fact, when
Right.
I was negotiating these contracts for my clients as a lawyer, every time I would push forward for the terms of service, I would get the pushback of, "No, that's just for using the website." Now, that's a debate that leads nowhere. Is it just for the website? Is it for the website and the product? But we would eventually sign a SaaS agreement, an MSA that was bespoke, tailored. I mean, it was based on a form, but it was negotiated and tailored to that given customer with the separate
Yep.
SOW and deliverables. So I guess as the product becomes pricier, the my comments about online terms become less relevant, and you enter the
Makes
bespoke
perfect
negotiation.
sense.
Exactly.
Yeah, that makes perfect sense.
Mm-hmm, mm-hmm. Before Atrium, before Legal and Ops, you were at Wilson Sonsini, which arguably is one of the best ECVC law firms. And as a side note, ECVC sounds a lot like a rock band, does it not? Like ACDC. Um, you correct me if I'm wrong. You cut your teeth there essentially as a startup lawyer, and being in that environment, you've observed, you've learned, and now you're running your private practice. What are some of the things that Wilson Sonsini got right that you're continuing that tradition through your private practice? What are some things that maybe they got wrong that you're doing differently today through your private practice?
The biggest thing I think Wilson gets right is the people. There are incredibly talented attorneys and incredibly good people, many relationships of which I've, yeah, been very lucky to maintain, our friends, our professional colleagues. Yeah, I feel like I can't speak highly enough about the people I worked with at Wilson and the relationships we've maintained since then. I think another one is the classic BigLaw drilling of attention to detail. Um, I have definitely made a lot of mistakes in the past, not, catching things that are subtle but important. And I think training there was really helpful for that reason. So I think those are two of the big things that come to mind. It goes without saying it's an incredible firm and they do amazing work. So yeah, I think it's a great resource for um, important tasks when deep expertise is required. And yeah, I have very positive regard in that way. I think probably in terms of improvement, I'm curious. I'm excited about what they're doing with Neuron, their tool to, as I understand it, automate a lot of routine corporate tasks. I am curious how it um, integrates into their business model. I think with a bigger firm with lots of overhead staff and operating on the billable hour, that it feels like there's a tension there. So I'm just curious to see, and they've got some very smart folks running it, so I'm sure they'll figure it out. I'm curious to see how they um, navigate that tension. I suspect it could be that actually a small portion of their work is this like not very high intensity, commodity work, and so uh, the ability to offer Neuron actually doesn't clash at all with their business model. But can't wait to see what they do with it, and I do think it's going to bring a lot of value to startups. So I'm excited to see.
Hmm. I'm with you there in terms of excitement. I like it when big law firms innovate in legal tech. Wilson Sonsini's Neuron is a great example. Gunderson Detmer is continually innovating in this space. Cooley has Cooley Go, great
Right.
tool. Um,
Yep.
I think this is the first step towards restructuring ECVC practices. And when I say
Hmm.
restructuring, I mean restructuring pricing models. Um,
Right.
I passionately believe that for early stage startups, early stage being up to Series B, the hourly rate makes much less sense than we think it does. A lot of
Mm.
stuff can be done on a flat fee
Hmm.
basis, on a subscription
Hmm.
basis, and these bigger law firms, or the big law firms rather, they tend to do everything on an hourly rate basis. And the most
Hmm.
incentive or concession they offer to founders is deferred rates. But deferred rates at $1,000 an hour or $1,500 an hour is still pretty high. It doesn't
Right.
really tie in with the way that founders should be thinking about pricing startup law or paying for startup law. So when
Right.
I see Neuron and Cooley Go and Gunderson Detmer's activities, I see that as a signal that this is going to be a move in the right direction. But to push them further along, and this is why Corpora is partnering up with boutique law firms, the boutique law firms are going to be the ones that are being the torchbearers in this move away from hourly rates for early stage startups towards alternative fee structures. Um, and this is going to put competitive pressure upon the bigger law firms in order to follow suit.
Hmm. And so you see that as a boutique law firms is more of an option because of the flexibility in pricing model. Is that right?
Flexibility, they're better suited to work closely with startups. Arguably,
Hmm.
they have uh, a smaller scope of clients than the bigger law firms, so personal relationships with all of them. But largely, yes, it's the pricing structure that just makes so much more sense, and the tech-enabled factor. Boutique law firms tend to be
Right.
more flexible with technology. They don't cross out, Google Workspace or Slack off the bat, as opposed to the bigger
Right.
law firms, which if it's not Net Documents or Outlook, then it's not going to fly. And
Yeah.
startups use Slack. Teams, maybe, but Slack.
So I take it. Yeah, I think it's definitely been my experience that bigger firms are more reticent about new tech, often for good reasons, concerns about information security, but often just inertia, I suppose. But it sounds like you're thinking about starting in boutique firms at least, which makes sense. And those kinds of early adopters, I feel like, tend to then ripple out to peers, right? It's the pressure
Precisely.
you're referring to. Yeah.
Precisely. And that competitive pressure, one, is going to come from boutique law firms. Two,
Yep.
from clients who will want
Right.
more competitive structures. And three, from
Right.
from the big law staff themselves,
Right.
associates, senior associates,
Makes
putting
sense.
pressure to adopt legal tech to make their lives easier. I
I
mean,
agree. Yeah.
the legal tech, they can take the grunt work. Neither of us took the bar exam to push paper, to conform dates, to check footers, and sure, like if you have a quota of billable hours to meet, maybe that helps you meet that time. But you're wasting your life doing work that just can be automated, and plus keeps you up at night when you randomly remember at 1 a.m. that, oh, I forgot to check that one footer, and we've already filed the document with Delaware Secretary of State. Why not just punt that to technology
Yes.
and
And
sleep better
that's
at night?
why, right. Even like leveraging Corpora for filing 83Ps, I mean, that is like a huge one to me because the black box of giving a client instructions around filing an 83P and then not knowing what happens. If you didn't incorporate on Clerky, I don't think you can use it for 83P filings as far as I'm aware. So that is like a perfect instance of it. And yeah, that hits, man. When you say that, like I feel it. Like I feel like I'm lying in bed at 2 a.m. So yeah, that definitely resonates.
Yep, yep, yep. The night tremors. Yeah,
Yes.
with our 83B, anyone, regardless if they used any platform in the world, they can file their 83B
Right.
through Corpora.
Yep.
Um, Tamara, let's go even farther back. Um, just to put it out there, you went to Harvard Law School for your JD, but before that, you went to U Michigan, where you double majored in philosophy and Near East studies. And I just found out about this. You got your degree in 3 years as opposed to the regular four. Like, who does that? How did you end up picking those two double majors, and why were you in such a rush, man?
Oh man, it's a good question. All of your questions are so thoughtful. I appreciate it. I think for me, it was a combination of like, what am I interested in, and how can I leverage this effectively? I feel like there's a lot of tragically gamesmanship in thinking about like GPA and like law school applications, and I felt philosophy would um, be good logic training for the LSAT, and at the same time, it's kind of like consistent with I guess my personality and what I'm into. So I actually started as a neuroscience major, and did it for about a year, but felt I was a bit not in my like forte zone. And so in that pivot, I was like, what else could I do? Maybe something that will like set me up for law school, but also something I'm interested in. That was the philosophy angle, and that was also the Near East studies angle for me as well. Something I was interested in, and something I thought I could be good at or would set me up for law school. So yeah, that was a bit of my heuristic. I think going back, I would index probably much more on stuff I'm curious about. I don't know about you, but I feel that all of my most successful like friends and colleagues are the people that have just always pursued the stuff they're curious about without worrying about like the gold star of like getting into the best law school or getting into the best law firm or whatever the case may be. So that was my story. But like probably all of us, I would definitely change some things if I were to do it over.
Hmm. But philosophy, I think that'll serve you very well in life, and has, I'm sure, served you very well in life. I've looked at your tweets, and you put some deep content out there as well.
Oh man, yeah. I try to use Twitter for like personal stuff, and LinkedIn for more professional stuff. But I kind of feel like there shouldn't be that, you know, kind of like a wall. Like it should just maybe just all be one person. Um, but this is the philosophy major speaking. There it is. The proof is in the pudding. Yeah.
Why 3 years?
Um, I think Michigan was amazing. I love it, but it was expensive as well because I was out of state from Ohio. So that was my effort to just keep costs down.
Wow, man, that's like a Herculean task. Do it in 3 years.
I mean, I think it comes from ultimately a place of privilege. High school, being able to take APs,
Mm,
feeling, I didn't have to work a job while I was in college, so I had more time. So, yeah, I definitely feel like it comes from a place of privilege. So, I feel
hmm.
very, very lucky in that way.
Amazing, amazing. And I want to read out this question, Tamer, because it ties into one of your professional callings at the top. Um, we we're living in fascinating times, right? Technology is changing at neck-break speeds. We have AI, spatial computing, blockchain. Who knows what's next? And similarly, we as lawyers are tasked with maintaining the status quo. I mean, the way I see it, the first time the lawyer profession was invented, so to speak, was when there were two people and they had a relationship, obviously, because there are two people, any kind of relationship, and there had to be some kind of norms based on which to decide what is right, what is wrong in that relationship. That's when law was born, in order to keep the peace and coexistence and make people get along with each other. But now we have tech, and tech is disrupting the status quo, if anything. How do we combine these two? How do we coexist as lawyers in a world where technology is so rampant? And the part that I want to read is how you put it in your bio. How do you connect that to achieving cognitive resonance of being a human while being a professional? Because I think this goes to the heart of the matter.
Yeah, man. Can I answer your question with at least a question? I mean, to get us started, how do you think about your calling? I mean, I'm just going to leave it there. How do you think about your calling personally?
One of the reasons that I quit law to build Corpora was because I trusted myself with building a company in this space that is ethical, and I wasn't sure if somebody else did it would be as ethical.
Mm,
Because seeing the two competing interests, the advancements of technology being on the precipice of the future, but also the heart and soul of our profession being um, conservative in nature, I felt like I trusted myself to bridge that gap. I would not trust anyone else
mm,
with bridging that gap as
mm,
successfully, which is the prime
mm.
reason why, one of the reasons why I quit and went all in on this in order to avoid a situation where somebody else would build a dangerous tool, if I may. So
Right.
that's my calling in response to this question.
So you are advancing legal interests for people using technology. I think that's is that a fair way to characterize what you're describing?
That is a fair way, while simultaneously combining the best of both worlds. So I feel like the pendulum swings to the extremes in this space. You either have the self-service tools, which try to cut out the
Hmm.
lawyer, or you have
Hmm.
lawyers, which are not very savvy with technology. There's a middle ground
Right.
as well, but we're trying to
Right.
champion that middle ground to bring the good stuff from technology and the good stuff from lawyers into one environment. Um,
Yeah. That
Serving legal interests.
definitely
Mhm.
resonates because it's, I think, the same thing. I mentioned a bit cheekily being motivated by spite in like building tech to automate routine tasks, but it's fundamentally about um, access granted on a B2B level. And there's so much, frankly, more important work on a B2C level around legal access. But the line is totally, I think, blurred between tech and law practice. I mean, I think the Bar Association tries to regulate unauthorized practice of law. And I remember way back when there were like forums on Novo, I think, that the Bar Association was not sure if it should regulate or treat as a practice of law. And now we're like way beyond that line. And depending on what jurisdiction you're in, it's clear or it's not clear. And so I think the line is totally gone. And at the end of the day, all you're left with is like trying to do what you just described your goal is of like improving essentially the ability to leverage tech to create, I think, access. Um, so it's almost like there's no distinction between like legal tech business and lawyer anymore. And so that's my feeling. All that being said, I think there continue to be like a lot of barriers to like really like self actualizing in that way. I think there's the reality of liability. If you build something that's broken, if you give bad advice, that really affects the way you connect or the kind of advice you give that might otherwise be much better. Um, I think our work is highly intense, and it's not realistic to always be on in that way. And
Mhm.
so you need to be doing something that's a bit more stimulating, I think, personally. And then there's just professional rules and navigating those, which just create a lot of, I think, at times unnecessary hurdles. So there's, I guess, what I'm identifying as a lot of barriers to like a fully committing to just, you know, improving access, whether you think about it as a lawyer or as a technology specialist. There are things that make it hard to act in an unfettered way towards that objective.
Mhm. Mhm. Are you optimistic about the future of our profession?
Oh man, I'm optimistic about Gen Z. I feel like they need to become lawyers, and if they do, they will steer the ship in the right way. I feel like millennials, we're just like doing our best in a sort of like pinched circumstance. Maybe that's like self victimizing, but I don't know. Like Gen Z is, I feel like, very aware of like social issues, important policy things that I feel like our generation just wasn't as focused on. So
Mm,
I hope they get into law because I feel like they will have an outsized impact. I'm going to say I'm putting my hope in them. Yes,
yeah.
I'm optimistic.
That's an insight I had not thought about that, but I'm with you in terms of Gen Z, not Jay Z, Gen Z
JC also maybe.
being yeah, more thoughtful about the social issues and us essentially serving as a bridge between the generation prior and the generation after. And
Yeah,
me too. I'm deeply optimistic about our profession. I think it's going to be elevated to a whole new level in 5 years, especially with space law becoming a thing, AI law becoming a thing, blockchain becoming a thing.
true.
It's going to be
Yeah.
fascinating. It's going to expand the horizons of our mind because lawyers like to think.
That's why, it's so cool that we get to be in this position to be on the front lines watching. So,
Yes.
yeah, I'm grateful to be able to do it alongside you and like have conversations like this.
Amazing, amazing. And before we wrap, Tamer, I'm noticing a statue in the background, above your left ear. Mind sharing with our audience what statue
Look
that
at
is?
that attention to detail. I meant for it to be Donnie Glover, so I made that. I think after a binge of Atlanta, and I love his like multi-talented kind of like writer, musician, actor. I think that's inspiring in terms of being a creative. So it's meant to be a reminder.
Yep, and very conveniently positioned next to a Marshall speaker.
That's right.
So
Yes,
there you have
yes,
it,
yes. Thank you. Yeah.
Tamer. I'm super happy we did this. It's been a long time coming, as you mentioned, over a
Likewise. Yeah.
year, and looking forward to keeping this conversation going. Thank you for being on the show.
Likewise, man. Thank you so much. I appreciate it.
Absolutely. Ladies and gentlemen, my special guest for today was Tamir Haddad, principal and founder of Legal Ops. See you next time. That's it.